As a function of the legislature's oversight responsibilities, today and continuing next Monday, March 6th, and Monday, March 20th, the committees will be conducting oversight hearings to review the several state regulatory entities under the Department of Consumer Affairs and the Business and Professions Code. These sunset hearings are part of the committee's ongoing responsibility to exercise oversight of agencies under their jurisdiction. The primary purpose of this review is to assess the effectiveness and efficiency of these agencies in protecting consumers and to determine whether changes in the law or in their operations or functions are necessary. Today, we will be reviewing specific issues regarding the Board of Chiropractic Examiners, Physical Therapy Board of California, the Board of Optometry, Department of Consumer Affairs, the Medical Board of California, the Osteopathic Medical Board of California, and the Board of Guide Dogs for the Blind. To assist members in their review and evaluation of each agency, staff has prepared background papers which identifies issues and makes staff recommendations for each agency. These papers have been posted on the committee's websites and made available to all interested parties. We will ask each agency to begin their testimony by providing members with a brief overview of their programs and to respond to some of the issues raised by staff. Members of the committees will also have an opportunity to raise any other issues or questions which they may have. We will also have the opportunity to hear from consumer groups, professional organizations, and members of the public for each portion of today's hearing. I'd like to invite Chair Salas, the Chair of the Assembly Business and Professions Committee, to make some comments, and then he will be conducting the first hearing for the Board of Chiropractic Examiners.
All right. Thank you, Senator Hill. Thank you, everyone, for joining us this morning. Joint committee hearing between both BMP and both houses. I want to thank my colleague, Senator Hill, and the committee staff for organizing the Sunset Review hearing. I'm pleased that our committees have worked jointly for the past 4 years to hold these hearings, and I know me and Senator Hill work very well together. The Sunset Review process is a continuing conversation about how to better serve our licensed professionals and improve their ability to function under the provisions outlined in statute. When the licensing entities come under review, the legislature and the public have the opportunity and the responsibility to work together to solve problems facing our licensees and protect consumers. This year, 13 licensing entities are being reviewed. We have examined each regulatory entity's focus on consumer safety, financial solvency, and regulatory efficiency. We will also hear from the Department of Consumer Affairs. The Sunset Review process is an important part of the legislature's oversight responsibility. We must maintain our accountability and state oversight. Remember that at the center of our policies and programs are the people of our state. By calling upon these state oversight entities every 2 to 4 years, we're able to dial in on systemic issues, delve into issues to make sure that consumers are protected, delve into issues at each of the licensees, at each of the boards to ensure that we are protecting the public as much as we can. I look forward to today's hearing. I want to thank our colleagues from both committees for joining us this morning as well, and look forward to the testimony and hope each of our boards that are before us will not only explain what has been going on since the last Sunset Review, but what issues there are, so as we collaborate between the two houses and the two committees in discussing remedies in statute and how long or whether to extend the sunset. With that, thank you, Senator Hill, for allowing me to give opening remarks. I believe, let's just call up the first board.
Sure. And here are the names of the examiners.
All right, fantastic.
Thank you. We'll now go to the item number 5, the review of the Medical Board of California. So please, Dr. Gananadev, Board President, Denise Pines, Board Vice President, and Kimberly Kirchmeyer, the Executive Director. All right, let's see what happens here. Good afternoon, Doctor. Welcome. It's nice to see you again. Ms. Pines, a pleasure. How are you, Kimberly?
Good afternoon, Senator Hill.
If you'd like to push that little green button there, it'd be great. Thank you.
Thank you, sir. Good afternoon, the chairs, Hill and Salas, and the board members. My name is Dr. Dave Ganadev, and in my real life, I'm a trauma and vascular surgeon from San Bernardino, and I'm the president of the Medical Board of California. I would also like to introduce my board vice chair and public member, Denise Pines, and the board's executive director, Kimberly Kirschmeyer. Ms. Pines and I will take turns in giving the brief report and responses to specific issues raised by the committee, and Ms. Kirschmeyer will assist us in answering questions. I would like to thank you for providing this opportunity for the Medical Board to work with the legislature to review the body of law that governs the practice of medicine, as well as the operations of the Medical Board. The board is a consumer protection agency which licenses and regulates physicians and surgeons and those allied health care professionals in California who fall under our statutory mandate. There are currently approximately 142,000 physician and surgeon licensees in California. About 110,000 of them practice in California. The board's primary mission is consumer protection. By statute, the board is authorized for 15 board members, 8 physician members, and 7 public members. The governor appoints 13 members, and 2 are appointed by the legislature, Senate Rules Committee, and the Speaker of the Assembly. The board currently has 1 vacant public member position. The board's budget for this fiscal year is approximately $63 million. Of the $63 million budget, approximately 67% is spent on enforcement. That includes complaint handling, investigation, and prosecution, 14% on licensing, and the remainder is expended on administrative functions and probation monitoring. If the board spends its full budget in this fiscal year, it will have approximately 4 months in reserve. The board takes its mission very seriously, as is evidenced by the significant number of changes that have taken place since the last Sunset Review report in 2013. In the last 4 years, the board has made the elimination of opioid abuse one of its main focal areas of improvement. The board has a significant role in this issue and took a very proactive approach to addressing this matter. The board established a prescribing task force and held multiple meetings to identify best practices, heard from speakers regarding this issue, and updated the board's guidelines for prescribing. Controlled substances for pain, which are adopted by the board in November of 2014. We did this before the CDC did. These guidelines are intended to educate physicians on effective pain management in California by avoiding under-treatment, over-treatment, or other inappropriate treatment of patients' pain, as well as recognition of addiction and appropriate treatment for addiction. The board also developed 2 public service announcements specific to the opioid overdose prevention. One PSA was specific to physicians and provided education on appropriately prescribing controlled substances to the patients. The second PSA was intended for the public and featured Olympic swimmer and gold medalist Natalie Coughlin. This video was designed to alert consumers to the dangers of abusing prescription drugs. The board also established, for a limited time, a group of investigators called Operation RX Strikes Force, focused solely on investigating the most serious overprescribing cases. The strike force performed numerous search warrants, filed a number of actions, and arrested multiple physicians and others. In addition, board members and staff have provided numerous presentations, including Ms. Kirschmeyer and I, on the issue of opioids and inappropriate prescribing to the physicians and consumer groups. In an effort to be proactive, the board established a data use agreement with the California Department of Public Health, that's CDPH, to receive death certificate when the death was related to opioids. Board was then able to use cures to identify physicians who may be inappropriately prescribing controlled substances. The board also requested information from the pharmaceutical companies who had identified physicians who may have inappropriate prescribing issues. All these steps have assisted the board in identifying the physicians who may be inappropriately prescribing in an effort to eliminate opioid overdose death. In July 2014, board established a new Compliant Investigation Office, CIO, made up of special investigators who are non-sworn, who began working the less complex investigations for the board. This unit, comprised of 6 special investigators and a supervising special investigator 1, was a result of portions received pursuant to the Consumer Protection Enforcement Initiative and is tasked with investigating quality of care investigations following a medical malpractice settlement or judgment, cases against physicians charged with or convicted of criminal offense, and physicians petitioning for reinstatement of license following revocation or surrender of his or her license. The establishment of CIO has assisted in reducing the caseload of the Department of Consumer Affairs investigators, in addition to resulting in quicker resolution of these cases. The board also established outpatient surgery setting task force, for which I was a member of in 2013, to review the board's existing OSS program and laws to explore ways to improve consumer protection. Based upon the info from this task force, the board sought legislation that require adverse event reports occurring at these facilities to be sent to the board, not to CDPH. The board now receives these reports and is able to not only evaluate the facility, but also look into the care provided by the physicians. The board also recommended legislation that would require all physicians within the OSS to have peer review, would require a shorter time frame for initial accreditation, and would require the OSS to check for peer review information for all the physicians working within the facility. In addition, the board made significant improvements to OSS database and website to make it more consumer-friendly. The public can now go to the board website and search for an OSS. The information contained in the database includes the owners of the facility, the types of services being performed, the status of the facility with the accreditation agency, and provides copies of the documents pertaining to an inspection of the OSS and any corrective action plans and follow-up inspections. And Ms. Pines will follow the rest. Thank you.
Good morning, chairs and members, and thank you for the opportunity to be able to present in front of you today. As he mentioned, I'm a public member on the medical board, and the board has made significant changes to encourage consumer participation at its quarterly board and committee meetings. Beginning in May 2014, the board began allowing the public to listen and comment at its meetings via the telephone. This allows individuals who cannot travel to the board meetings to be able to provide input and comment to the board. In January 2015, the board launched a Twitter account to educate consumers and physicians by providing information on the board's roles, laws, and regulations, as well as providing information on the board's events and meetings. Twitter provides outreach, and this supports the board's consumer protection mission to the public and encourages public engagement in the activities of the board. The board completely revamped its home webpage to make it more user-friendly and to further the board's outreach campaign, which encourages patients to check up on your doctor's license. The changes include easy access to the board's license profile page, the page to file a complaint, and the page to find public enforcement documents, all right from the board's homepage. The board also made its license profile page more user-friendly and provided a document that outlines what the information provided on the physician's profile means, and developed a tutorial that walks a patient through the steps to look up their physician on the board's website. The board reports the CEPEI performance measures to the Department of Consumer Affairs on its intake, investigation, and formal discipline cycle times, as well as on its probation intake and violation response times. For all performance measures, except formal discipline, the board establishes its own target. At this time, the board is not meeting its target for enforcement measures. However, it is meeting the goal for probation measures. With improvements to the investigation and prosecution processes, the board anticipates that the performance measure timelines will decrease. In addition, the board has established its own performance measures for licensing. The board requires that every application be reviewed within 45 days. The board is currently exceeding that target and is reviewing applications in 29 days of receipt. The medical board's goals for the future are to make needed changes to vertical enforcement model and the complaint review process to enhance consumer protection, reduce enforcement timelines, continuous efforts on eliminating opioid misuse and abuse and inappropriate prescribing, and continue its efforts on ensuring all Californians know how to check up on their doctor's license on the board's website to ensure consumers are informed.
Mr. Chair, I would like to respond to 4 issues raised by the committees. I'll respond to 2, and Ms. Pines will respond to the other 2.
Very good.
First one is issue number 27, vertical enforcement. In 2005, SB 231 established a VE model. Under VE, the investigators from the Department of Consumer Affairs are paired with prosecutors from the AG's office, AG's HQES, Health Quality Enforcement Section, from the initial assignment of cases for the investigations all the way through the final prosecution of the case. The board submitted a report to the legislature in March 2016, which included a review of pertinent data from the VE model. As identified in the report recommendation, the board believes that changes are necessary to the VE model. In this respect, the board recommended that the government code authorizing this program be amended to more fully utilize the expertise of both investigators and the prosecutors. In addition to that recommendation, board does believe that there should be a discretion in terms of determining which cases will be investigated under the VE model. The board has seen the benefits to specific case types being placed in the VE model. If these specific case types were kept in the VE model and all other cases were investigated through the normal investigation process, this would enable the prosecutors to focus on the highest priority matters from the perspective of consumer protection. We believe there is value for using VE for these specific case types, but not for all cases. The board looks forward to working with the committees, the AG's office, and the Department of Consumer Affairs to identify the needed changes to this program in order to enhance consumer protection and reduce the enforcement timeframes. Second issue I'm going to talk about is issue number 2, data sharing. Over the last few years, the board has entered into agreements with state agencies in order to receive information that will assist in obtaining information regarding physicians who may be violating the law, or obtain information that assists the board in its procedure. The board entered into a data use agreement with CDPH to receive death certificate when the death was related to opioids. The board received data from CDPH and death certificate related to opioid deaths, and is in the process of analyzing the data to identify physicians who may be inappropriately prescribing opioids. In addition, the board has a long-standing agreement with CDPH to receive death certificate information on deceased physicians on an ongoing basis in order to update physician license records. The board also entered into a data use agreement with the Department of Healthcare Services and Department of Social Services to receive information on physicians who had prescribed 3 or more psychotropic medications to foster care children for 90 days or more during July 1, 2014 to December 31, 2014. This data was received by the board and is going through the enforcement process. This data use agreement was codified in the statute, and the data is now required to be provided to the board on an ongoing basis for 10 years. The updated DUA was just finalized last week, and the board should be receiving data for the calendar year 2015 by tomorrow. Through a review of data received from DHCS and DSS, the board identified numerous patients who may have been inappropriately prescribed psychotropic medications that needed further investigation. The next step in this process is for the board to obtain authorization to request medical records for patients identified. The board has requested the assistance of the DHCS and DSS in obtaining the medical records for these patients. At this time, board staff is awaiting assistance from the DSS and the counties to identify who needs to be contacted to request authorization for the records and to establish a process to receive these records. Without receiving authorization to obtain the medical records, the board will not be able to move forward in investigating these physicians. In addition to this agreement, there are several other state agencies and other data that could be obtained to assist board with its enforcement role. The DHCS audits and investigations unit performs billing audits and may identify physicians who may be violating the law. The board needs to receive enough information to be able to pursue an investigation, and these should always be sent to the board. In addition, CDPH audits hospitals and other facilities. If information is obtained regarding a physician in violation of the law, that information should be provided to the board with enough information that the board can pursue investigation. And finally, if CDPH, through its review of labs, identifies a physician who is receiving inducement, that information should be provided to the board. The board agrees with the committees that this information is useful to the board, but the referral provided must have enough information for the board to adequately investigate the issue. The board would support any legislation that would require data sharing between state agencies, thereby assisting the board in identifying physicians who may be violating the Medical Practice Act. Such legislation should also ensure that board receives enough information to perform an adequate investigations. The next 2 items will be done by Ms. Pines. Ms. Pines.
Okay. I'm going to address the fun issues. The issue number 25, disparity in enforcement actions. The California Research Bureau's report on demographics of disciplinary action by the Medical Board of California between years 2003 and 2013 was requested by the board in response to concerns about bias in the board's disciplinary process. It is important to note, due to limitations in the study's design and methodology, the CRB was not able to draw definitive conclusions regarding the drivers and the scope of the disparities highlighted in its report. Despite the limitations, the board takes the disparities highlighted in the CRB's report very seriously. It is taking proactive steps to investigate and address them. In response to the report, the board established a task force of board members to review the report and deliver specific recommendations on how best to proceed. The task force had its first meeting last week to begin identifying available training and possible next steps. The board has been looking at available training on implicit bias that is already being provided to other entities. The training on implicit bias will be provided to all individuals in the enforcement process, from board staff and members, to investigators, experts, prosecutors, and judges, if not already required. The task force will also review existing complaint, investigation, and disciplinary processes to better understand the institutional and procedural issues that may have contributed to the disparities outlined in the report. The task force recommendations are going to be presented at the board's next meeting. The board currently utilizes the Department of Consumer Affairs non-discrimination policy and complaint procedures, which must be reviewed and signed by all employees. This policy states that the DCA enforces a zero-tolerance policy against discrimination, harassment, and retaliation. Every year, all employees must review this policy and indicate that they will comply with the policy. The next issue I'll talk about is issue 26, complaints. Complaints are brought to the board's attention through a variety of sources, including patients, family members, licensees, other state agencies, the media, mandated reporters, and other state disciplinary actions, and any other means of receiving information about a physician who may be violating the law. While the steps to process a complaint may be different based upon the type of complaint, all complaints go through the same process of triage and initial review by the board's central complaint unit. Investigation is warranted if either the board's non-sworn investigators or the Department of Consumer Affairs sworn investigators, and prosecution by the Attorney General's office. As indicated in the report, over the past 4 years, the board has seen an increase in the number of complaints received. Accordingly, the board also saw an increase in time frame to process complaints within the board's central complaint unit. Due to this increase in fiscal 15-16, the board was able to obtain 1 additional staff member through the budget change proposal process to assist in the complaint triage. In addition, the board is seeking 2 more analysts this year through the budget change proposal process to review and process complaints within this unit. In addition to requesting additional staff, the board has made business process improvements to assist in decreasing timeframes. Such process improvements include performing quarterly case reviews on all complaints pending within the unit, and reviewing pending reports to follow up on complaints that are not moving forward in a timely manner. These pending reports were just recently able to be obtained and have greatly improved the follow-up on complaints. It is the board's policy that individuals who file a complaint with the board are notified at various stages within the enforcement process. Upon receipt and opening of a complaint, an acknowledgement letter is sent to the complainant. This letter informs the complainant that the board received their complaint, and if they have any additional information, that they may submit it to the board's complaint unit for review. This letter provides examples of what type of additional information may be included. In addition, the board recently developed a letter that is sent to patients or plaintiffs in malpractice cases who may be unaware that the board received a mandated report complaint. This letter informs them that the board received this report, asks them to provide additional information they may have, and outlines the board's statute of limitations. When the board sends a request to the complainant for the release of medical records, the board also informs the complainant that they can provide additional information to the board regarding their complaint. During the complaint review process, if the complainant calls the board, staff also informs them that additional information can be provided. For quality of care cases, the complainant is notified that all medical records have been received and that the complainant is going to be sent to an expert for review. For all cases, if it is determined that the complaint is moving to formal investigation, then the complainant is sent a letter notifying them of this transition of the case. Once the complaint goes to formal investigation, The complainant will be contacted by the investigator. If the matter is referred to the Attorney General's office, the complainant receives a letter notifying them that the matter has been referred and also receives a letter and a copy of the accusation when it is filed. Lastly, if disciplinary action is taken, the complainant also receives a copy of the final decision in the matter. For complaints that are closed by the Central Complaint Unit, the board sends the complainant a link to the Consumer Satisfaction Survey. However, the Sunset review process and feedback from other parties, the board has identified that not all complainants have received the survey link, including those complaints went to investigation and proceeded to disciplinary action. The board is ensuring that this link will be added to all closing letters from the board, including those letters sent after a formal investigation and after disciplinary action has been taken. The board's statistics indicate that a large majority of complaints received by the board do not meet the board's high burden of proof of clear and convincing evidence that would support the filing of an administrative action. The board understands and empathizes with the patient or patient's family who may have filed the complaint only to have it closed by the board. However, in quality of care cases, these cases are reviewed, in some cases twice, by a well-qualified expert in the same specialty or practice area as the physician. If this expert does not find a violation or finds one simple departure from the standard of care, this does not meet the criteria for filing of disciplinary action. Although there may have been a poor outcome or patient harm, the expert may find that the physician did not deviate from the standard of care. The board must rely on the expert's opinion. Again, the board understands the frustration that may occur based upon the board's closure, but the board must follow the enforcement process and must have enough evidence to meet that clear and convincing burden of proof in order to file a disciplinary action.
Mr. Chair, in closing, issue 30, I would like to thank both committees for allowing the board to respond to the questions you raised today. The board appreciates this opportunity and looks forward to working with both committees and their staff on the issues that have been identified for future consideration. The board is pleased that the committee staff has recommended the licensing and regulation of physicians and surgeons and allied health professions continue to be regulated by the Medical Board of California in order to protect the interest of the public and be reviewed once again in 4 years. Thank you.
Very good. Thank you, Doctor. We'll take the issues and see if there are questions that the committee has. And I'll just start, if that's all right, with issue 27, the vertical enforcement. You mentioned the backlog and the not meeting the targets for enforcement and the challenges that you face there. Do you feel that if you had more discretion in which cases, how they would go, that would be helpful? And do you feel that vertical enforcement is kind of causing this problem?
Senator, the simple answer
Causing the
yes.
delays? Yes.
But I'll have Ms. Kirschmeyer explain what exactly we're looking at.
Right, thank you, Doctor.
Yes, absolutely. We believe that discretion would be very valuable to the board because we do believe that there are certain cases that have value by being put into the vertical enforcement process. However, not all of the cases, and therefore we think that the law should be changed to require some of those cases to be in there or leave it to the board at their discretion as to which cases would be in the vertical enforcement process, and then the others would remain in the normal process of going through and being investigated, and then if there's a violation that needs further action, then transferring that onto the department or the AG's office.
Very good, thank you. Questions on vertical enforcement issues? Yes, Assemblymember Baker.
Which ones do you think would be best suited for vertical and the regular way?
So in looking at it and looking at data, it was actually provided in 2013, and just from our experiences. We believe that sexual misconduct cases are one of those that definitely need to be in that process because there's value in having the Attorney General involved in it and in that first victim witness interview. That's really valuable. And so those cases, mental impairment cases are another one because we actually have to have the petition drafted by the Deputy Attorney General if we're going to compel that individual. That would be another one. We've seen significant improvements in those that are those high-profile urgent cases where we need to enter into or try to obtain an interim suspension order. So those cases, we've definitely seen those cases be valuable in that VE model where you have them working together so we don't have any delay in knowledge transfer.
Very good. Chair Salas.
Actually, Assemblywoman Baker just asked a question I was going to ask exactly how that would work and what it would look like, because we know, reviewing the data right now, the VE model actually is prolonging.
Right.
And so how would we get at it, actually reducing and then doing the high priority? So thank you.
And then it would pull those cases out to where the other cases could move
Correct.
forward.
So we could get those more egregious cases taken care of.
Then on vertical integration, are we ready to? Mine deals more specifically with the issues around addiction, and we got rid of the diversion program that's gone now. We're setting up the health and wellness program, and so I'm just wondering, and we're talking about the opioid addiction overprescribing, but on the physician side, if a physician is arrested, how soon does the board find out about that, and then what is your recourse?
So at the arrest, because we do fingerprint all of the physicians, the medical board is immediately notified once those prints are rolled. So in those counties where that happens, we actually get that notification through DOJ. And so we immediately open a case against that individual. And in some instances, depending on what it is, we'll go and refer those immediately for investigation. Some of those cases are the ones that we've now transferred to our non-sworn investigators because you have a conviction on those cases where we can actually take action. But with the elimination of our diversion program, what we do is we continue through the disciplinary process against those physicians. So we go through, we file an accusation, and those will lead through to disciplinary action. And then on the probation end, if they get probation, then we ensure that we have biological fluid testing, psychiatric evaluation usually, and then psychotherapy for those individuals. So it's really up to them to find a program that is going to help them to abstain from alcohol or drugs, but we do monitor them, and we do random biological fluid testing for those individuals. And that will happen until we get our new program.
Have you seen any difference between when we had a diversion program and we didn't on rates?
So I can say we have more disciplinary actions resulting because of it, because in the past, it was actually a diversion program where we didn't take disciplinary action. They went into that as a sidebar to discipline. And as long as they successfully completed, then we would not take action against them. The new program won't be like that. It isn't a diversion program, but that is the difference that we've seen an increase in disciplinary actions on substance abuse.
And what's your timeline for setting up the new program?
Well, we're looking at our regulations right now. So we actually held an interested parties meeting on January 11th to kind of flesh out some of it because, again, we have to stay in complete compliance with the uniform standards. So we had interested parties meeting because we want to get them on board before we get into that regulatory process. And so we're hoping that by our October board meeting, we will have language to go forward for regulations by our board and that would be a regulatory hearing at that point. Then it'll go through the normal process, and we're hoping that we'd have regulations by early 2018 because then we have to do a request for proposal to get a vendor in, and then we have to do regs again for the cost because this is actually the participant has to pay for it. And so we have to do that after we get the vendor to know what the cost will be to do those regs. So we're looking at July of 2018 at the earliest, I believe it would be implemented.
Okay, thank you.
Yeah.
Other questions related to item number 27 or issue number 2? Chair Salas, did you have further on issue 25 or 26?
Issue 25, I was just wondering if the board, I know we've talked about this before, and you mentioned in your testimony about, but is the board looking to create a formal policy against racial discrimination, and if so, what's the timeline on that?
So as far as a formal policy, that's why we mentioned in our background, talking about that there already is a current policy with the Department of Consumer Affairs, but we believe that we really need to go that extra step as far as getting the training out there that's not required right now amongst all of our individuals. And so although I don't think that we need a formal policy because we already have one that's being signed by everyone, I think we do need that extra step of training that's out there.
Got it.
And that's an implicit bias, not just diversity, but an implicit bias, that it sounds like it's actually a really good training.
Correct, yeah, and I know some of the law enforcement agencies do it on the implicit biases. And so if you integrate that into your training programs, how that would work, and when do you see that as soon as?
I would hope to have a training set up by our next board meeting, which is in April. Okay. Where we can actually have people start taking it. We'll probably have to go through a contract to get, because I'd like to go outside and get that training. And then we also want it set up for a webinar because we have about 2,000 experts who have a definite, fish in this game. And so we want to make sure that those individuals actually take the training too. So it has to be on a webinar basis because they're located all the way throughout the California.
Thank you.
Thank you, Chair Salas. I'd like to move on, if I could, to issue number 28 that was related to patient notification of those doctors on probation and whether that is something. Doctor, why is it that the medical board is reluctant to notify patients when their doctors are on probation?
It's a pretty complex issue, Senator. Let me have Ms. Kirschmeyer answer that first.
I think when we actually went before the board, when the petition came forward, there were a couple things that they brought up. They didn't want it to interfere with the patient-physician relationship that was happening, and they were afraid that it would actually have an impact on the time frame for that physician to be able to see the patient, because so many questions would come up at that time. The other thing I think that they really thought was that right now the information is out there for individuals, and so the patient themselves have that right to look up that information and obtain that information rather than having to have it told to them. I know when we've actually done some of the outreach that we've done with individuals where we've set up a computer in the malls and asked individuals, would you like to look up your doctor? We have information on your physician. Several individuals actually stated that they didn't want to know that information. And so right now we believe our website provides all of the information that an individual needs to know. It's just that we really need to make sure that individuals are aware of the medical board's website and all of that information is there for them.
So I guess, as I look at the appendix to the background paper today, and I look through all of the doctors in California, there aren't that many. I mean, frankly, of 140,000 physicians, excellent work, and we're talking about 400 or 500. I just pick a couple of them. Convicted of unlicensed practice of medicine, sting operation of laser led to arrest for unlawfully performing Botox, laser hair removal, other procedures. This is just one that I found, and you don't think that affects the patient-doctor relationship by having that as a background that the patient should be aware of? I think it's fairly clear, and I could go through and list a number of them, but to claim that the website is the only form of access to this information, as the background paper states, there are many examples where, especially related to seniors who are most inclined to be seeking medical attention, they're in many cases computer illiterate, they don't have access to computers, they're not using them, and people of color in some instances in more instances are not familiar with that. So to expect them to do that makes no sense. Is one of the reasons, concern that I have is when you look at the majority of the board, they are physicians, and I think they're members of the California Medical Association, which has a strong position in opposition to patient notification. Do you feel that that has anything to do with this position of the board?
No, sir. I'm emphatic on that one. I don't think so. I think many of these probation orders were actually by ALJs. They're not stipulations for the ones you're talking about. The board, in the end, does whatever it can take actually to revoke license rather than put some of these people you talk about on probation. Our preference is actually to revoke license rather than put on probation. So that's what we are still working on this, Senator, as we mentioned before, that we continue to see how we can satisfy the notification requirement at the same time actually do not destroy that doctor-patient relationship. I don't know, if I go to a doctor, just to go to a primary care doctor, and if the person says to me, oh, by the way, I'm on probation, there goes my whatever trust I had completely gone. And there is no more sacred relationship in my mind as a physician for about 40 years than what is between a doctor and a patient. It's one-on-one. That's about it. So,
Isn't the fact that you are dishonest with the patient by not disclosing and telling that patient that you are on probation or that there are conditions to your probation related to your practice of medicine, that's not dishonest?
all that information is provided before the patient goes, Senator. So that's all I can tell you, because that information is available. And we're also looking at what other ways we can provide that information can be there in doctor's office. We haven't gone there yet, but we're seriously looking at it.
I think Chair Salas and I have a further question. You got to follow up to one of these.
I did. I was just wondering, and listening to Senator Hill, when a complaint is filed, or if I'm a patient and I have an issue, somebody back in the district, are they ever informed if their complaint led to a disciplinary action?
Yes, they get a letter.
Proactively?
Yes, those individuals get a letter along with a copy of the actual decision. And just one other thing, Senator Hill, I wanted to add on to is a couple things. The board, as Dr. Gonadev stated, we have not finished this issue at the medical board level. We did have an interested parties meeting on January 11th where we talked about this and adding in a condition into our disciplinary guidelines that would require patient notification, and it would allow it at the discretion of the board to add that into those probationary orders. We're also asking for changes to the notice that goes into the doctor's office about the medical board and being more proactive that way to inform patients when they go into that doctor's office with the notice that's posted there. And then lastly, any legislation, we will look at that. As you remember, we were neutral if amended on the last one. So.
I do remember and appreciate that. Just wanted to follow up. We mentioned the California Medical Association, and the issue has come up, and they have raised it. They raised it last year. They're raising it now this year, that the due process is, the challenge of due process in arguing against patient notification. And I believe now they're arguing against the due process in the disciplinary procedure that you follow at the medical board, and I sense that from just legislation that has just been authored and sponsored by the California Medical Association. Do you feel that you follow due process and that physicians are given appropriate due process when they go through the system of discipline through the medical board?
On the bill, I think board hasn't taken a position yet. I think Ms. Kirschmeyer can give staff report. As far as I'm concerned, I know it sounds awful, but there is too long of a due process. It just takes 900 days sometimes to take a bad doctor away. It really worries us. That's not consumer safety, so that's protection. So that's what we're trying to, we're asking you what, within the law, what can we do to expedite the process?
Yeah, and I mean, I think that's what we all are looking for. So I guess the concern is that when a person were to try to locate the status of their physician, they would have to go to the website at this point in time and look at that. But how does the medical board enforce the terms and conditions of probation? How is that done?
So we actually have a probation unit that does that. And I know that basically for the last year and a half, we actually hired a new chief of enforcement. And when she came in, that was her main focus, is making sure that we have 15 inspectors statewide that are assigned a caseload, and it is their job to enforce all of the terms and conditions of those probation monitoring. And we did find deficiencies there, and that's something we really have been looking at. And over the last, just even in the last 8 months, we've issued more cease practice orders than we've issued any year previously. Just in the first 6 months, we had issued about the same as we'd issued in the year before. In addition, we're referring more cases to the Attorney General's office on those individuals who are violating their probation. We're doing quarterly case reviews of all of those inspectors' workload, with making sure that they are monitoring all of those conditions. And so that's how we're doing that, and that has actually been one of our focuses in our enforcement.
Well, and I appreciate that, Ms. Kirschmeyer, because you're making my arguments for me. Because what you're saying is that these physicians, there's 500 or 600 in the state who are on probation today, are violating that probation, just as the study that was not recently, but the most recent study that you have indicates, and as the background paper indicates, approximately 30% of physicians who are on probation violate, and they recidivate. And I guess that's the part that's troubling, especially when if you look at some of the conditions of probation. In fact, I look at San Mateo County, the county I come from, and I just find, the first one listed is an individual who is on probation and shall have a third-party chaperone present while consulting, examining, or treating female patients. And I think even the third one has the same condition. Yes, the third one has the same condition. So my concern is many of these physicians who are on probation are probably solo practitioners, because medical groups may not want to affiliate with them or take the exposure or the risk of that, especially with the 30% recidivism rate. So this is in my county, and if my wife or my daughter were to go to that physician, how would they know that those terms and conditions, what the terms and conditions are to start with, but whether they are being followed today so that they're not being unchaperoned in a exam room with that physician? I mean, that's the troubling fact that I see with non-notification of patients, and especially in light of the recidivism that we've seen. So how does the medical board guarantee my wife and daughter's safety in that?
Well, for that particular instance, if an individual actually has to have a third-party chaperone, they do have to notify their patient that they have that requirement of the third-party chaperone. That isn't on all conditions, though. Yeah, because I just yesterday ran into someone who is a patient of this physician and had no knowledge of the fact that he's on probation. So it's interesting. You're saying not everyone is required to notify the patient. I see, okay, because in that case, they certainly didn't. But I guess the concern I have is in an age where we advocate for patient empowerment, I mean, and as well as patient protection, how can this be achieved if patients don't have the information that's truly critical for their care? And that's a concern. So any other questions or comments on this issue? Okay, we will open this for the public. If you have public testimony, and if you could be fairly brief, we would appreciate that.
Right.
All right.
Cut me off if I get too winded.
Well, that's all right. Just to try not to be redundant, and that's okay. Most important.
Real quick, I just want to show you, this is my sister, Callie Andrus. She died of medical errors. I'll be talking about her when I speak in this. I gave up my career in the entertainment industry in 2003 to care full-time for my elderly mother and disabled sister. Our mom checked into a hospital for elective surgery that October, and she died the next day because she contracted a hospital-acquired infection that caused sepsis. At that point, I was on my own to care full-time for my disabled sister, Callie, who was born mentally retarded and had the learning ability of a 4-year-old. 9 years later, my sister was rushed to the emergency room at the very same hospital. 2 days later, she too was dead from gross medical errors. Without any physical examination, she was simultaneously given a deadly combination of a painkiller 7 times stronger than morphine and a radioactive beverage to drink for an unnecessary CT scan. Due to the sedative effect of the pain medication, she ended up aspirating the radioactive beverage into her lungs. which caused pulmonary edema and sent her into cardiac arrest. The hospital then erroneously treated her as a do not resuscitate, even though she wasn't. And then they stood around doing nothing while she laid there with her heart not beating. When they realized they were wrong, they called a code blue, and they did revive her 17 minutes later, but it was too late. She was nearly brain dead by then. She died the next day when I was forced to turn off her life-saving machinery. Despite the harmful effects of California's microlaw, I was able to file a lawsuit and was forced to settle, even though we had a very strong case. Now, wouldn't you think that sounds like a perfect case to bring to the medical board to file a complaint with them? Well, I turned to the medical board in hopes that they would finally hold this doctor accountable. After filing the complaint, there was no contact from the board at all until I contacted them myself 6 months later. They wrote me back and told me that my complaint had been closed due to there being no evidence that the doctor had breached the standard of care. My sister was dead, but the doctor hadn't breached any standard of care. I was shocked. Is there a standard of care so low that patients can be killed by medical errors and doctors can get away with it? No one had ever contacted me from the board to even say they had received my complaint. No one called to interview me or get additional evidence, like a copy of the private autopsy report that I had performed on my sister proving the negligence. On a whim, I called the hospital to see what records they had provided to the board and found out that, in fact, the medical board hadn't requested any records at all. I finally found out that they had received an uncertified copy of the records from the very doctor named within the complaint when he had to report the lawsuit settlement. After complaining to Enforcement Division Chief Christina Delp, who I think is here today, they supposedly reopened my complaint and finally got a certified copy of her records from the hospital. After 8 more weeks of hearing nothing from them, they just closed the complaint again. Once a complaint is closed, consumers have no recourse to make sure their complaint was handled properly or even handled at all, or that the assigned medical expert was qualified or even looked at the medical records. The medical board seals it up tighter than Fort Knox. I honestly can't help feel that closing the complaint wasn't out of retribution for pressing them on other matters that have led me to co-writing a report which I have provided to all of you called The Medical Farce of California. I hope you've all had a chance to look it over, and if anybody wants a hard copy of it, I brought a dozen copies with me today. We raise over 24 questions in this report, including the possible conflict of interest of Medical Board President Dr. Dev Ganadev in restoring the license of his fellow medical school alumni and co-worker, Dr. Hari Reddy. Dr. Reddy was convicted of the sexual assault of 4 women, including a 16-year-old minor. We outline for you how the medical board allows registered sex-offending doctors to practice medicine and how much of their public information is either hidden from view or has been illegally purged from the Breeze system. We show you how they've not only closed my complaint, but have stories of 4 other victims, and 2 of them are here today, of our healthcare system and an uncaring medical board staff. We detail with examples of how difficult it can be to use their online information system, Breeze, which also contains erroneous information. We detail how we have been blocked at almost every turn when we have filed Public Record Act requests, mostly by Carrie Webb, who is here today.
Mr. Andrist, I'm going to have to ask you to please.
Okay, well, I have a statement that I would like to present to you. How can we do that?
I'll just be happy to give it to the sergeants, and they'd be happy to do that. Because
I've got it all written down.
We will read it all. Thank you very much. And if everyone could identify themselves when they come to the microphone, that would be appreciated. Thank you, Mr. Andrist.
Good afternoon. My name is Marian Hollingsworth, and I'm a patient safety advocate from San Diego. First, I urge you to require the medical board to have doctors on probation notify their patients, especially for egregious offenses. Patients have the right to know the safety background of their doctors so they can make informed choices, give informed consent on their own medical care. Next, we have come here on our own dime to ask you to make the medical board do its job to protect the people, not the doctors. Investigations can be tainted with exceptions and conflicts of interest. Even board member Dr. Michael Bishop broke rank recently and said, and I quote, "The system is broken. The system is broken. It failed my father through exceptions." He was a victim of deliberate medical harm. He was given black box antipsychotic drugs without our knowledge or consent, which led to his death. Consent forms were falsified, even a do not resuscitate order. I was told there would be an accusation against the doctor, but 6 months later, it was suddenly reduced to a simple public letter of reprimand. The doctor agreed to take classes at pace within a year, but a year and a half later had still not done so. This is normally a cause for discipline. Executive Director Kimberly Kirchmeier told me the doctor claimed the classes had not been offered. So I checked with PACE myself and was told that these classes were offered at least quarterly. Ms. Kirchmeier then promised me an investigation. The next business day, the doctor suddenly handed in proof of classes. Did someone tip her off? The public letter of reprimand posted days later was pitiful. It was filed under BNP Code 2233, which is reserved for minor violations. My father died, so how was this minor? My complaint took 3 years and 2 months to complete. After this, Ms. Kirchmeier told me that the board is allowed to make exceptions. But according to BNP Code 2229, exceptions cannot trump public protection. I'm almost finished here. Now, regarding conflicts of interest, I urge you to investigate whether board president Dr. Dev Gananadev had a conflict of interest when he served in a panel for a doctor he apparently knew not once, but possibly twice. That doctor had lost his license for the sexual assault of 4 women, one of which was a minor. This doctor had been denied reinstatement in 2008, but in 2012, the panel Dr. Gananadev was on reinstated his license. A short time later, Dr. Gananadev filed paperwork to open a new medical school in the Inland Empire. His partner in this venture is Prime Healthcare CEO Prem Reddy, who happens to be the brother-in-law of the doctor who had his license reinstated. In 2015, Dr. Gananadev served on a second panel with this doctor. Now, this smacks of conflict of interest. I trust this committee to investigate to see if indeed there was an actual conflict of interest. Please help reorganize this agency so that exceptions and conflicts do not get in the way of protecting California consumers from truly dangerous doctors. Now, I do have a longer version of my testimony since there are a number of committee members who are not here. Should I just submit it to?
Yeah, that'd be wonderful if you would be kind enough. Thank
Okay,
you.
thank you
And
so
you
much.
did identify yourself, is that correct?
Yes, I get Marion Hollings.
Thank you very much, Marion. Appreciate it. Our next witness, please. And thank you for submitting the statement. Good afternoon.
Good afternoon. I am Rosanna Davis, a California licensed midwife and the president of California Association of Licensed Midwives, also known as CALM. We are the state professional society for licensed midwives, who are also regulated by the Medical Board of California. Licensed midwives are specifically educated and trained to provide maternity care in out-of-hospital settings, in our clients' homes, and in freestanding alternative birth centers. I also serve as president of the California Association of Midwives, our nonprofit public benefit corporation whose mission is to educate California families, policymakers such as yourselves, as well as increase access to patient-centered, evidence-based midwifery care. I wish to thank the committee members here today for providing this opportunity for me to testify. I'd also like to especially thank the staff of both committees for their review of our comments on the Sunset Review Report of the Medical Board and their assistance with getting us up to speed for this hearing. My testimony today provides CALM's response to the issues regarding licensed midwifery raised by the staff's background paper, particularly the matters highlighted in issues number 4 and number 30, which raises 2 questions. Are certain clarifications in the law necessary to reflect these providers' roles? And number 2, how does the Medical Board of California work with licensed midwives and the licensed midwife stakeholder groups? CALM agrees with the staff that both of these issues must be addressed during the present Sunset Review. 3 issues warrant clarifications in the law. Peer review.
Ms. Davis, if I could just make one comment. If you have that written in a statement, because we certainly want to hear that and want to include that in the record, so it would be helpful if you could submit that now, and that would be, I think, appropriate and maybe a better way of doing it so that we can really respond and make it a formal part of the record.
May I take a minute to finish?
Of course.
Okay. Thank you. So we're concerned with having licensed midwives listed as care providers that have protected peer review as all other healthcare professionals do. To be able to form professional corporations as all other healthcare professionals are allowed to do, as well to have exemptions from being sued if they provide care in a medical disaster. And then we'd like to figure out how to get the CPSP provisions implemented. We're at a stalemate because of the rulemaking process that is tied to the CPSP implementation, Comprehensive Perinatal Services. And then lastly, I'd like us to begin conversation about having the Midwifery Board as an independent board, not under the regulation of the medical board. And the reasons for that are in my written testimony. I'm happy to answer any questions anyone has.
Very good. Thank you, Ms. Davis. And just to let you know, the staff recommends and agrees with most of your comments. And so and look forward to working together as we move forward to see if we can do this.
Thank you.
Thank you. And independent board, best left to the sunrise process that we could undertake to do that. So thank you.
Good afternoon.
Good afternoon.
I'm Jen Camel. I'm the founder of VBAC Facts, an educational, training, and consulting firm whose mission is to increase access to vaginal birth after cesarean. In that capacity, I work as a consumer advocate, national speaker, legislative consultant, and an expert witness. Today, I'm speaking on behalf of families regarding the importance of VBAC access. This issue is relevant to the regulations of licensed midwives by the Medical Board of California, because VBAC is the issue that has caused the present impasse in MBC's barrier to exercising its rulemaking responsibilities. Currently, 44% of California hospitals ban VBAC, meaning that they require all women with a prior cesarean to have a repeat cesarean. These policies are strictly enforced despite ACOG's and the NIH's assertion, National Institutes of Health, that VBAC is a safe, reasonable, and appropriate option for most women. ACOG stated in their 2010 VBAC guidelines that even if a hospital bans VBAC, women should not be forced or coerced into a repeat cesarean. But this recommendation is simply ignored by many facilities throughout California. 50% of California hospitals that attend VBAC have VBAC rates lower than 11%, contributing to the 89% repeat cesarean rate in California. California ACOG now wants to impose a VBAC ban on out-of-hospital birth by requiring California obstetricians to predict how an individual woman's birth will play out in order for her to plan an out-of-hospital VBAC. Understandably, no obstetrician is willing to do this because they cannot see into the future, and no medical malpractice insurance provider will permit this. This is the issue over which MBC is presently at an impasse, and it is within this climate that women choose out-of-hospital VBAC. Women should not have to feel like out-of-hospital VBAC is their only option, but for too many women, their choice is limited to out-of-hospital VBAC or a repeat cesarean in the hospital. And so if the state of California, through its laws and rules, prevents women from having access to out-of-hospital VBAC, it is forcing these women into cesarean surgery, which has a 3 times higher rate of maternal mortality, putting her life and health at greater risk. In this sense, we must recognize that childbirth is a reproductive right and a matter of a woman's choice. In light of the recommendations made by ACOG National and the National Institutes of Health, and the realities of increasing maternal morbidity rates in the state of California due to multiple repeat cesarean sections, we should all be working together to improve the public health by making VBAC more accessible. Thank you.
Thank you very much. Our next witness, please. Good afternoon.
Hello, good afternoon. My name is Tanya Smith-Johnson. I'm the president of California Families for Access to Midwives, or better known as CFAM. I'm a Navy veteran, active duty military spouse, homeschooler, and student. But most importantly, I'm a mother of 5 and pregnant with baby 6, and a mother who has birthed all of her births with midwives. I've birthed in all settings. I've birthed in the hospital, freestanding birth center, and my last 2 births have been at home. Like many families in the state of California, I chose the midwifery model of care. My last 2 births were here in the state of California. Yet many families in California are unable to do the same. They are being denied access to affordable midwifery care. The passage of AB 1308 allowed midwives to be autonomous care providers. SB 407 made it possible for midwives to become CPSP providers and accept Medi-Cal. This was seen as a victory for so many families here in the state. No longer would midwifery care be cost prohibitive and unavailable for those receiving Medi-Cal. But it's been 3 years since the passage of AB 1308 and a year past the deadline for the Medical Board of California to complete the ruling. Delays in implementation of the CPSP bill due to ACOG's insistence on restrictive regulations on the way licensed midwives practice is impacting the health care of thousands of families in California. 1 in 8 births in the United States take place here in California. When half of those births in California are to women on Medi-Cal. It is an egregious disservice to think that the option to see licensed midwives as care providers is being impeded by this impasse. The true stakeholders are women and families, not ACOG. And we want the freedom to choose our care providers. We should be listening to women and families who are saying they want midwifery care. We want the freedom to choose midwives as our care providers, and the choice should be available to low-income women, women on Medi-Cal, and families who otherwise could not afford it. Licensed midwives have done all that they've been asked to do to become autonomous and fully qualify as CPS providers. They are ready and wanting to offer their services to us, and thousands of us are ready to receive their care. CFAM supports holding the MBC accountable for impeding midwives from qualifying as CPS providers. We support licensed midwives being regulated by their own board and no longer regulated by a board that doesn't have midwifery representation present or fully understand the difference between the midwifery model of care and the medical model of care. CFAM respectfully requests that the committees and the staff consider to develop legislation for transferring the regulation of licensed midwives from the medical board to an autonomous licensed midwives board within the State Department of Consumer Affairs. We also support the amendment to relevant sections of the CPSP bill to allow families the freedom to choose midwives and midwifery model of care. The families of California have been patiently waiting long enough.
Thank you, ma'am.
Thank you for your time.
Appreciate it. Thank you. Next witness. Good afternoon.
Good afternoon. Alicia Sanchez, representing the California Medical Association. We don't always agree with the medical board, but we do think that they have been responsive to many of the issues that have been raised over the course of the last few years since the Sunset review process. And we agree with the staff recommendation that the board's authority should be extended. The analysis raises a lot of issues, many of which are very complicated, and the language of the legislative proposal is really going to matter in our ability to do an analysis. So we look forward to continuing to provide feedback as we go through this process. We want to thank the committee for including issue 19, the issue of utilization review in the staff analysis, and we look forward to hearing updates on that. However, there are a few issues in the staff analysis on which our position at this point is clear. We continue to oppose the elimination of the corporate bar on the practice of medicine, issue 12. As we've expressed in multiple venues, the corporate bar is a fundamental protection against corporate financial interests driving patient care decisions. We disagree with the assertion that changing the corporate bar will increase access. The 2016 CRB report that was referenced in the staff analysis was inconclusive as to whether the corporate bar would increase access to care. And AB 2024, which was passed last year, which would create a temporary exemption to the corporate bar for critical access hospitals, requires a report back to the legislature on the program's effectiveness. We believe a conversation about the elimination at this point without that additional information is premature. We continue to oppose the idea of mandatory notification of probation, issue 28. We continue to be concerned about the due process issues that we raised on SB 1033. And we disagree, Senator Hill, about the assertion that our proposal, AB 505, which we introduced after hearing the concerns about probation being an inappropriate disciplinary action for many of the cases being discussed, does not include due process. Additionally, we believe that the Sunset Review is not the appropriate venue for this clearly controversial issue. We take issue with the assertion in the staff analysis that a stipulated settlement is an admission to violating the charges, and that accusations are equivalent to proven charges. This is not an accurate portrayal of the process. It only serves to further confuse the public, and it decreases our confidence that this venue is appropriate to address this concern. The staff analysis raises the issue of cost recovery, issue 14. The current license fee includes a $15 that's spread across all licensees to pay for the cost of what the medical board previously recovered through cost recovery. Should the committee seek to reinstate, or committees seek to reinstate the cost recovery, we would request that the license fee be reduced accordingly. Without that, the physician would be paying twice. We do question, however, the rationale for seeking this reinstated cost recovery, as other boards have shown to have varying degrees of success in actually recovering the costs that have been ordered. The Board of Optometry is reporting that only 21% of the amount ordered is being actively collected. The Acupuncture Board is reporting a return of 3% on unrecovered costs in its 2015 Sunset Review report. We do support the idea of readdressing vertical enforcement, issue 64, though I would note that we have in the past opposed what was suggested by Mr. Howard, which is moving the investigators to the AG's office. So I'm sure there will be ongoing conversations about that, but wanted to put out that we do support reviewing and readdressing vertical enforcement. And as to the other issues in the report, our assessment on the language, as I noted, will be language dependent, but there will be important factors that we'll be considering. What is the impact on due process? Physicians, as all other licensees, have a constitutional right to due process, and the language must maintain those due process protections. What is the impact on patient privacy? Both federal and state law establish patient privacy protections because of the very sensitive nature of medical information. And when you start to consider making changes to those, they need to be very carefully weighed, the balance between the desire to change it and what the impact would be. And is the issue one that's better addressed consistently across all types of healthcare licensees? For example, the report suggests adding physician-specific requirements to the office notifications that are currently required for all licensees. What about physicians recommends a different requirement from physicians from those other licensee types? We appreciate the opportunity to provide this analysis and continue to have a dialogue with you as the process continues.
Hey, thank you. Next witness, please. Good afternoon, sir.
Good afternoon. My name is Mario Guzman, and I live in San Jose. And I came here today to ask for your help for the Senate to bring back accountability and demand accountability and transparency to the California Medical Board. Look at me. I'm a victim of medical negligence, malpractice. Back in 2013, I was a triathlete and marathoner. However, a series of utterly avoidable medical mistakes led me in this chair a shadow of my former self. I demanded justice, and for a while it seemed that I was gonna get it. After I filed a complaint against the doctor that hired me, an investigation by the California Medical Board found her to be below the standard of care and was referred to the Attorney General's office for disciplinary action. Imagine my surprise when the complaint was closed without explanation and, most importantly, without any sort of disciplinary action. I spent months seeing my limbs fall off my body, and the doctor that hired me has a spotless record. A little research showed me that this surprise was misplaced. After all, the California Medical Board dismisses 95% of the complaints it receives. Not only that, but it also seals those files from external review. So there is no way for the victim, in this case me or any other, of an independent audit to find out why their suffering was left unaddressed. For many, medical malpractice is an abstraction. To some, it is just an excuse to shake money out of the physicians. But the reality is that the preventable medical errors are the third leading cause of death in the United States. I am the consequence of a medical establishment that allows mediocre, drug-addicted, pill-vending doctors to continue practicing unscathed for years under the complicit eye of the California Medical Board. I came here to demand change. I came here to bring some light to the injustice because I am still alive, which is not the case for many of the victims. I ask for your help, Assemblymen and Senators, to bring back transparency and accountability to a consumer protection agency that long ago lost its purpose. Because for the California Medical Board, impunity and disability are acceptable. Thank you.
Thank you very much. Appreciate you coming today.
Hello, my name is Ludmila Parada, and I am from San Jose, California. One thing that has always brought my attention, and I think it has been like the big elephant on the counter on this room, and it should be of the most important for all of us, you know, congressmen, you know, citizens of California, is the fact of who pays for medical negligence. You know, who ends up paying for the bill when somebody ends up dead or disabled, you know, as a result of a preventable medical error. I gotta tell you, it's not the doctor. You know, between tort reform and arbitration clauses in medical provider contracts, you know, less than 3% of victims ever go to trial, and less than 0.75% ever get any sort of financial compensation for their troubles. I gotta tell you, it's not the hospital also the ones that ends up with the bill. You know, when a patient falls on the hospital or gets a hospital-acquired infection, that hospital continues billing private insurance, continues billing Medicare, continues billing all of us for that medical treatment. Do you know who pays? All of us pay. Preventable medical errors are believed to be the third leading cause of death in the United States. Research shows that between $73 and $98 billion a year are the cost of medical errors. But if the estimate of a recent paper on the Journal of Healthcare Finance is correct, the actual cost between indirect and direct costs is 10 times higher at a tag of almost $1 trillion a year. Given this reality, it would be plain common sense that a consumer protection agency such as the California Medical Board, you know, would discipline and limit the ability to practice of that 6% of doctors that account for almost 60% of malpractice insurance payments. Unfortunately, that is not the case. This board, throughout the years, have actively pushed for policies that put Californians' lives at risk. It refuses to mandate doctors on probation to disclose their disciplinary status to patients. It recently approved the reestablishment of the diversion program that allows substance abusing physicians to continue practicing during the disciplinary process. You know, this was a program that was struck down several years ago because it was proved to have harmed several patients.
That's absolutely true, and the new program is not a diversion program. It's completely different than the one that you're referring to.
Still, this is a board that closes 95% of complaints and seals them from any sort of review. We don't even know if they're reviewed at all. How is this good public policy? It puzzles me, but maybe it shouldn't. You know, when we look at the financial incentives that the board has, you know, it's not surprising at all. My husband is this man right here. He is now on Medicare and Social Security 20 years before he should have. His medical care will cost millions of dollars throughout his life. We're all paying for it, not Kaiser Permanente. But be assured that the California Medical Board will allow the doctors that cause these sorts of errors for years, and we all will be paying for it. Thank you.
Thank you. Appreciate you coming today to testify. Thank you. I know it was a challenge to get here. Good afternoon. Welcome.
Excuse me. My name is Carrie, and I was sexually assaulted by my doctor last year. I contacted the medical board after the incident and was told at least 2 other women had filed complaints in prior years. No action was ever taken against him. If the board had taken action and revoked his license or placed him on probation, I may not be a victim. I was told by the medical board staff that they didn't have enough staff, resources to adequately follow through with their complaint and weren't sure what, if anything, would happen to the doctor. More or less, I'd be put on a shelf. After the investigation, I felt like I was a victim again, and not just by the doctor, but also by the medical board. Working with the sex crimes unit at LAPD, I decided to participate in a news conference to raise awareness about sexual assault by the doctor. Since my news conference in December, many other victims of this doctor have come forward, many victims. I'm here today because I want to prevent others from this happening to them and becoming victims, and want other victims to know that it's okay for them to come forward. The best way to prevent other patients from becoming sexual assault victims is to file a complaint with their local law enforcement agencies and the medical board. I urge the medical board and local law enforcement to take action as soon as sexual assault claims against the doctors are filed. I was told that the medical board was supposed to work side by side, and it's not happening.
Okay.
And it's something that really needs to be kind of addressed, okay? I urge the medical board members of this committee to require doctors who are on probation be required to notify their patients. Doctors throughout the state are currently on probation for sexual assaulting patients. They've already eroded the trust of their victims. Patients need this information so they can make an informed decision. I had gone on site to the medical board before I had gone to this doctor to look to see if there was any claims against him. Nothing was posted at the time. And here recently went on again. I couldn't get on to find out if there was any information about any doctor. It's not easy to get onto your site and find information that I should know. I don't have to know every little detail about a claim, but I need to be at least aware that something's going on so I can make a good choice if I want to go to this person. Thank you.
Thank you for being here today and sharing your story. Appreciate it. Good afternoon, ma'am.
Hello. My name is Carmen Bulver. I'm the Executive Director of Consumer Watchdog. And we were here 4 years ago when this committee issued a scathing report on enforcement and doctor discipline at the California Medical Board, threatened to shut it down if it didn't clean up its act and start protecting patients. 4 years later, the medical board continues to fail in its primary mission, which is patient protection, not physician protection. I have to say I was really offended by the absurd comments by Dr. Ganadev that in one hand, patients should be perfectly fine with the information that they're able to get online at the medical board's website. So they have all the information they need about a doctor's probationary status. Yet Dr. Ganadev doesn't want to actually tell them because that might impact the patient-doctor relationship. It's just shocking. It's speaking out of both sides of their mouths, and it really shows how little physicians at the medical board want patients to be informed. You know, this is, they talked about, you know, holding, putting out tables at the mall to inform patients how they might look up their doctor. This isn't a bake sale. This isn't the Girl Scouts. We're talking about patients' lives. We're talking about the people like the patients who came here to speak, who didn't know about dangerous doctors and are facing the results. So number one, we strongly support the committee's recommendation that doctors be required to inform their patients if they are on probation. Not only because they should know, but because it is so difficult for a doctor actually to get on probation in the first place for doing harm to a doctor that you know these accusations and these disciplinary actions are severe. What we far more often hear from patients is that they submit a complaint, they get a letter saying we got your complaint, and a little while later they say it was dismissed without cause. So frequently we hear from patients who were never interviewed by an investigator, never interviewed by a medical expert. We hear from patients whose medical records have been falsified. Doctors add or change things after the fact, but those are the records the board is relying on to decide whether or not there was a departure from the standard of care. And so we also urge this committee to require the board to speak to complainants before they close a case. If we were talking about a rape case, the doctors wouldn't take evidence and speak to only the person who was accused of the rape. They would talk to the victim as well, but the medical board doesn't do that, and that's outrageous. So we urge the committee, again, we were here 4 years ago with exactly the same problems. Little has changed, and if we continue to repeat history, we're going to get the same results. So we urge the board to mandate these changes in the enforcement process or shut down the board. We should start over if they're going to continue down this road. Thank you.
Thank you.
Good afternoon, Mr. Chairman and members. John Valencia. I'm here on two matters. First, on issue 25. On behalf of the Latino Physicians of California, we're heartened by the board's response to the Golden State Medical Association's urging to pursue the report, but we're concerned that the responses and the reactions lack one critical thing that we think should come back before the joint committees, and that's a diagnostic as to the causality. My board of directors includes a former member of the board, the Medical Board of California. We'll be engaged in a detailed communication to the board with copies to this committee. And again, while we find the initial responses heartening, we find that the disproportionality of enforcement for a population that, at least in our case, Latino physicians, represents fewer than 3% of active physicians in California, warrants a deeper dive into causality, quite simply. Shifting gears and shifting topics very briefly, the committee is in possession on item 11, the notion that an alternative pathway for accrediting boards to petition the Medical Board of California, have equivalency standards reviewed for recognition of specialties in California, not for practice, since we don't stratify the practice of medicine, but rather for advertising one specialization. So on behalf of the American Board of Cosmetic Surgery and the California Academy of Cosmetic Surgery, our clients in the matter, we ask that you refer to our detailed communication. Of course, we, as an active applicant, this oversized paperweight is essentially 1/3 of the documentation that we have pending before the board. We join with the at least one of the several boards that have been affirmatively reviewed previously by the medical board over the last 27 years, during which time the two private nonprofit, which is not to be confused with not-for-profit organizations, have recognized only one specialty, that specialty being, thankfully, medical genetics and genomics. Thank you, Mr. Chairman. Thank you, members.
Mr. Valencia. Next witness, please. Mr. Madden.
Yes. Chairs, Tim Madden, representing the California Society of Plastic Surgeons, and following up on issue 11 that was just previously talked about, our organization supports the notion of eliminating this process for the medical board to be reviewing the specialty boards. We agree that the medical board is not in a position to review this, and I think given the volume just shown is an example of how this is a tremendous undertaking, and the question of whether the medical board is situated to properly review this, I think is a good one, and we agree with the medical board that this might not be the best place for them. Thank you for your time.
Thank you, Mr. Madden. Appreciate it.
This is very, very brief because I want you to like me, and I'm not going to take away from anything anybody else said.
Very, very briefly,
Why aren't you
please.
hair testing addicted medical personnel? Michael Allen Hirsch was a sex offender doctor who got himself off Megan's Law. The medical board's anemic letter to me thanking me for turning in Ray Robles is now public on my Facebook page. And you need a sunset review next year, not in 4 years, not in 2 years. You need it next year.
If you could identify yourself again, please. Ma'am, could you just say your name again, please, on the microphone? Just identify yourself. Thank you.
Drinker, D-R-I-N-K-E-R.
Thank you, Mr.
Ironically, one of my relatives invented the iron lung. My first name is Evelyn.
Evelyn, thank you very much.
Drinker, D-R-I-N-K-E-R. Check
Thank you.
with Boston Women's Public Health Hospital.
Appreciate you being here today and for speaking twice. Anyone else care to speak before the committees? Seeing no one, we'll bring it back to the committee. If there's any thoughts? Very good. I had one question, and it was raised at actually the first comment, and a question related to if someone sends a complaint or an issue or raises a question and they send it by electronic form, do you send it back in a different format? Is it, or should you be sending, if you're doing it in email, if you receive the communication in email, to respond in the same format? Which seems to make sense. Is that how it's done, or it seemed to be a problem before?
We usually send it hard copy mail back to the individual. We will communicate, some of our analysts will communicate with the either the physician or the public or the complainant via email, but usually those final actions, we usually send those in the mail to them. We can attach it to an email to them, but we always want to make sure that we're putting that out there to them that way.
Okay, that may be good to attach it to an email as well, so that they get it both ways. It may be, or at least that they make sure they do get it. So that's good. I see no further public comment, no questions or comments from the committee. Thank you very much for being here today and for your participation. Appreciate it. Thank you. You want to take the rest? I'm going to go to
Next one, right?
yeah, which is
Someone you can. All right, thank you. Thank you guys for your testimony. Thank you for everyone that showed up here today. With that, we're going to go ahead and conclude the joint sunset review oversight hearing between the Assembly Committee on Business and Professions and the Senate Committee on Business Professions and Economic Development. Thank you all for attending.